Can you hear us?
Now I can hear you.
All right,
Perfect.
very good.
Hi. Marcy, I love your glasses.
I thought I was.
Now you're good.
All right, well, we'll call this public session of the Board Policy Committee to order. And I'll take a roll call. Dr. Betty Lusk. Dr. Amanda Whitmire.
Here.
All right. We're now move and Ms. Askew will be joining us, I believe, a little later. Now is 1C to adopt the agenda. Can I get a motion to adopt the agenda?
I move to adopt the agenda.
Okay.
I'll second.
Moved and seconded. I guess I'll do a roll call. Dr. Lusk,
Aye.
Dr. Whitmire.
Aye.
All right, motion passes. All right, we're going to move to the Pledge of Allegiance. Can I ask Marcy to lead us in the pledge? We have a flag up on the screen.
Ready, begin.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
All right. Now's the time in the agenda for public comment. Members of the public wishing to address the Board Policy Committee on matters within the jurisdiction of the committee, but not on the agenda, may do so during public comment for up to 3 minutes. Public comment on specific agenda items will be heard under that item. Any public comment not present? I will ask if there's public comment on the guest on the Zoom link. Okay, hearing none, we will close public comment and now move to review, discuss, and action. The first item 2A is to review, discuss, and make recommendations for board policy and administrative regulation from the California School Boards Association March and July updates. And we're going to start with human resources. And what I would like to suggest, because there are so many, if there are ones that maybe we could go through them, and then if there's ones that are particularly want to spend some more time on, then maybe Dr. Whitmire, Dr. Lusk, you can just let us know. Otherwise, we'll move somewhat quickly to ensure that we can get through the pretty heavy agenda. So this is human resources, so I'll turn it over to Dr. Nunez. There's a lot of doctors in the house tonight.
Yeah, so the first one is Board Policy 1312.3, this is regarding UCP, Uniform Complaint Procedures. The major change there is to reflect the new law, SB 95, which adds PE instructional minutes as potentially something that people can file a complaint on. And it also adds the health and safety of our preschool programs, and that they're consistent with our FPM monitoring instrument. So the criteria have shades, playgrounds, all those things. The AR is the same. It updates the same law, SB 795, with the same requirements. So, and it also includes the preschool as well. The health and safety of the preschool.
Right.
I didn't have any comments on this one, but on the AR, there was an option 1, option 2, and I wondered if there was a staff recommendation.
So option 2 is what we would probably go with, Dr. Whitmire. It's normally what we have in place now. There's several exhibits that are included in there, but we usually use the exhibits that are just provided by the California Department of Education every year. And we do share those with staff, parents, and students as well.
Thank you.
Williams, AR 1312.4. So that one, it deleted some material that had some non-compliance with health and safety, as well as moved some of that material to another board policy in AR that is consistent with the federal program monitoring instrument. And if you recall, we did an FPM audit with last year, Costa, and a lot of this is in line with what we have.
So this is AR 13.
13.4. Yeah.
I did have a question on this one. So I'm using the big PDF document that we got sent, but it's page 3 of this particular item, but page 176 of the larger PDF. And at the top, it says any district serving any grades 6 through 12, in which 40% or more are from low-income families, will stock at all times at least half the restrooms with feminine hygiene products. And I just wondered if we were doing that or if we're prepared to do that. Because that's new to the policy from what I could tell.
Yes, well, I'll let Ryan Altemeyer, because facilities is under him, talk about this.
Yeah, thank you, Dr. Pittenbaugh. We absolutely do comply with this. We do make sure that the bathrooms are stocked with the feminine hygiene products. So we're in compliance with that. They have plenty of stock and those are replenished just like any other item that would be replenished in the bathrooms where they're equipped.
Yeah.
Awesome. And I think we're stocking these in the resource centers as well. I just want to make sure we're in compliance with the policy.
And the exhibit included in that piece as well is we have exhibits that we utilize to post in the classrooms, like we normally do when we have to go through the Williams study for our Title I schools, as well as the sample exhibit that is under the federal program monitoring, which we were solid last time we did it.
So we were in compliance.
We were in compliance every year, so we have to keep checking.
All right.
Okay. AR 4030, the non-discrimination in employment. That regulation is updated to reflect the new federal regulations, which, if you're probably aware, there's been a lot of changes with Title IX, the new federal guidelines. So it's reflected to include those changes that are described in an AR that we're going to review later as well. But it's heavily focused on the Title IX complaint procedure process.
I had a question. Make sure I'm on the right part. Yes, AR 4030. On number 7, districts where 10% of the employees have a language other than English, does MPUSD fall into that category? It stipulates that we have to translate policies into that language.
Yeah, so we translate pretty much anything into Spanish because that's not only for our families, but we have the documents available in Spanish. And I've had to deal with one employee who requested the documents in Spanish. and it was provided to them, and they filled it out in Spanish, and I just translated it.
Okay, good.
Don't we have, okay. Don't we have on our website, for our policies? Go ahead.
The translating version, yes.
Yeah.
Yes.
So our website translates to hundreds of different languages, so it's all in English, and then you click whatever you want, and it translated, and then same thing with Parent Square, we've been sending a lot of things out to staff now in Parent Square, and I automatically hit the Spanish translation button, so like the e-news that goes out and everything that goes out, it translates for them in Parent Square as well.
I've noticed that, and I've had several parents, one in particular from the Navy school that
Mhm.
made me aware that they were accessing it and were sharing with other parents the availability of it. So that's good to know. I think that perhaps should be communicated in one of our newsletters or
Sure.
somebody communicated on an ongoing basis to
Like
parents
reminding them.
that, yes, just reminding them.
Okay.
Okay.
Number 5, the one that I have. I got jump off my feet.
Thank you.
It's really good, actually.
Looks better.
I'm trying to find my notes in the-
We're doing some lighting adjustments in here, Dr. Whitmire.
Wondering what was going on.
Yeah, all of a sudden the lights went
Just went
off.
dark.
Oh, we're so energy efficient, right?
Yeah. Yeah,
There you go.
there we go.
There you go.
So this board policy is on a certification, and really the update that was provided here is the hierarchy that we need to follow if we're able to hire a person who possesses a clear credential or a preliminary credential in correspondence with the CTC guidelines. As well as, the exceptions that are there, like we can hire somebody and put them on a variable time waiver and interim credential. And so it gives us a little bit more clarity. It also highlights national board certification, and for us as a district to create incentives for our teachers to participate in that process. So it just provides the clarity for that certification to take place.
I didn't have any questions or comments on this one.
The next one is employee notifications. And that's just an exhibit, but it gives us clarity on all of the new laws and the notifications that we have to provide to employees. It's quite extensive, and these go out through Parent Square, either through the employee handbook, just different ways for us to communicate with them, like things like sexual harassment policy, all those compliance requirements that we have to meet.
I'm good.
Seven is board policy 4413, an assignment. And I'm using numbers because that's the way I'm coding, so I'm just going to say board policy 4113. That board policy was updated to reflect the new law, AB 1219, and it just requires the annual monitoring of the assignment of certificated employees, and requires the CTC to administer a statewide system. So all of the monitoring before was done manually by paper, but now the CTC has moved on, and we're now doing everything online. And we just completed that this past month, so it happens in October, November of every year, where we have to make sure that everybody's credential is clear and that they're teaching what their credential says they're equipped to teach.
So we have no misassignments,
No,
as
so
would be declared in the Williams.
there are times that we will have a misassignment, but we usually work with that individual either to correct the misassignment. We'll have to hire somebody that's in an entry credential for the time being, pending enrollment into a credential program, and we work with that staff member to get that, and then it no longer becomes a misassignment.
They give you, at least in Williams, they give you, I think it's 30 days or 60 days to
60 days.
fix it. Yeah,
Yeah,
yeah. So we have, within that time frame, we've been able to solve any issues.
Okay, thank you.
yeah, and the administrative regulation 4113 is the same thing. It just updated to make minor corrections for gender neutrality. That was the only change that happened in the AR.
I'm good on that one.
Number sexual harassment, board policy 4119.11. That policy and all policies related to sexual harassment are updated to reflect the new federal regulations. One is it requires that the complaints meet the federal definition of sexual harassment. As a district, we're in compliance with that. We had an extensive training. We have to have different members form part of that team. It can no longer just be one person overseeing sexual harassment. Those are the new guidelines. We have to have a mediator. We have to have investigators. We have to have a decision maker. We have to have a Title IX coordinator. And so that board policy is reflected in there, and we have those things in place already.
Yep, I'm good. Nothing for me on this one.
Training,
Yep.
that's something that
Every staff member completes the training. This specific training, we had to receive it through a law form because it's specific to that group. But every staff member receives sexual harassment training, and every manager receives, and leader, every 2 years they have to do the extensive sexual harassment training.
Thank you for that.
I do have a question about the AR related to this one. In the section on the second page of AR 4119.11 under prohibited conduct. First paragraph, conduct is considered to be sexual harassment when made against another person of the same or opposite sex. That language to me implies a gender binary, and I wondered if we could use something like made against another person of the same or different sex instead.
Yeah.
Okay.
Yeah.
I can support that.
And just FYI, Wendy's in here now.
Oh, okay. Welcome.
What was that?
Hi, Wendy.
Wendy has joined the meeting.
Hi, Wendy. Oh, I didn't mute it.
Okay. So we're in AR 4119.12, and that's Title IX sexual harassment complaints procedures. This is a new AR. It's in reflection to the new federal regulations that were just established. To have a Title IX complaint procedure for addressing obviously those complaints, and the process that's outlined in the AR. So this is a new AR completely due to the federal guidelines that were just established.
I had a question on this one. On page 5 of this BP, is it the B, am I in the BP or the AR? It's so hard when you're scrolling through. I'm on the AR actually for Title IX. Should we do the BP
Yeah.
first?
No, I think we're on the air.
Okay, so on page 5, under the written decision, so the superintendent shall designate an employee as the decision maker. who's not the Title IX coordinator? Have we had discussions about who that person would be? Would that person change depending on the situation, or is there going to be sort of a go-to person for that?
Yeah, we have two decision makers. One is the HR coordinator, and the other one is the assistant to direct services. So those are the two staff members that are right now designated as decision makers. So with this AR, it also goes into like investigators. We have to designate investigators that are different than the Title IX, but Dr. Diffenbaugh and I had extensive discussions of the makeup of the team, and it involves district personnel in different roles, and we took into consideration gender as well, just in case, we needed to, the comfort of people as they fill a complaint.
There was extensive training that these folks had to go through as well to be investigators in this. But you're exactly right, Dr. Whitmire. It would depend on the situation. Who would we assign to be, sensitive to the particular situation to ensure that there's no bias or conflict of interest or anything of that nature.
Thanks for clarifying.
Yeah, and the training did cover that, like the bias and then the approaches we should take when we're going into a situation like this. BP 411942. That's focused on bloodborne pathogens. The policy is just updated to add the requirement that we have a control plan for bloodborne pathogens and that is consistent with the district injury and illness prevention program per the labor code. As you know, all of our employees receive bloodborne pathogen training through Keenan, who is our sort of illness prevention provider, and that's done every year. The AR that follows is similar. The key thing here is that they added a definition of personal protective equipment, and they deleted the requirement to communicate hazards to employees through labels and signs, which doesn't apply to us as school district. And it adds more detail about first aid and the pre-exposure of hepatitis B. And it adds the required, obviously, training that we comply with on a yearly basis.
I'm good on this one.
And then the exhibit is something we have in place. It's just acknowledges, employees sign this as part of them acknowledging the hepatitis B declination if we need to. Part of the onboarding packet. Board policy on universal precautions. That board policy has been updated to include material that was in the AR related to immune deficiency syndrome, AIDS, and the conditions in hepatitis B, and the appropriate methods to prevent exposure. We do have the option to add a paragraph in our employee handbook, and to my knowledge, I reviewed the employee handbook and it was not there, but that is an option we can add to the employee handbook.
I think that's a great idea.
Okay, great. The AR updates the definition of what exposure is, and it adds a section on employee information and moved it to the board policy, as I mentioned earlier. And then there's a section in there on infection control practices that is more specific to the requirements that employees need to be aware of. So it just deletes the language and puts it into the board policy. The board policy on employee compensation, board policy 4151. That policy is just updated to delete labor code citation that is not applicable to public agencies. And it reflects education code provisions related to overtime for classified employees.
That's it.
That's good.
All right, if there are no further questions on this, on any of these, would like to ensure that there isn't anybody in the audience or online that would like to make any public comments regarding any of these proposed board policies or ARs. Okay, not seeing anyone. We'll entertain a motion to, this is to adopt the recommendations to bring it forward to the full board for these set of policies having to do with human resources.
I'll move that we adopt.
And I'll
These
second that.
All right, so move and adopt and seconded. I'll ask for each to take a vote. Dr. Lusk,
Aye.
Dr. Whitmire,
Aye.
and Ms. Ruth Askew.
Aye.
All right, motion passes. Thank you, Dr. Nunez. We'll move on to 2B, review, discuss, and make recommendations for board policies and administrative regulations for California School Boards Association, March and July 2020 update. And these are items under business services. So Mr. Altemeyer will go through these, and just as the last time, if there's, we'll move pretty quickly, but let us know if there's questions or just interrupt to make sure that we give it the time that you would like. So I'll turn this over to Mr. Altemeyer.
Thank you, Dr. Diffenbaugh. The first policy for review this evening is AR 3231, which deals with federal impact aid. This is a new AR, and it outlines specifically, we receive federal impact aid for students who reside on federal property. This AR includes language around students who reside on Indian lands within the district boundaries, and what we must do to engage those families and parents as it relates to the dollars that we spend with the federal impact aid. To date, as far as I'm aware, we don't have any families that fall within this classification, but that's the main changes for that AR.
My question was, did we have any families? You've answered that, so thank you. Okay.
No questions, nothing. Yeah.
So moving on to BP 3471 parcel tax. This just adds language around the major requirements for levying a parcel tax. Mainly around what the limitations of the parcel tax could be, the approval of a resolution, the public hearing, all of the things that would need to happen in order to approve a parcel tax.
I'm gonna move back to the impact aid one. Is it the impact aid one? That's the new one?
Since it's a new one, do you want to bring
Impact
it
aid
forward?
was a brand new
Does it
one.
apply to
So
the
they use
district?
it. It wasn't just an update. We don't have that, so.
Yeah, this is a new one.
Okay, so he says, just,
What do you need me to do? So
This one.
This one?
like, he wanted me to share something. I think we're good.
Okay,
We good?
good, okay. All right, we were on.
Parcel tax.
Mhm.
Just for clarification, I'm not sure if it's in here, but my understanding is if the district wanted to go out for a parcel tax, it would have to happen on an even year election, or is that just a general obligation bond, or is that in there at all?
It's not in the policy, I
Okay.
believe. Let's see. There's vote in order to be placed on the ballot, the resolution should include the type rate. It doesn't specifically call out in this, but I believe that is in the even year as well, but I'm not 100% certain.
I'm good on this one. No questions.
Okay. Next policy is BP 3551, Food Service Operations and Cafeteria Fund. Page here, sorry. So this is an existing BP and AR, but they're revised. And it reflects the new law, which outlines that unpaid meal fees for students. Any student who has an unpaid meal fee, we cannot deny them a lunch. We will provide them lunch, which we do in our district. But this is in alignment with new law SB 265, and it's adding that into the policy. And the other main component of this is we're not able to have any action toward the students for any unpaid meal debt. So it's not, as far as it relates to SB 265. We must treat those students the same as we would treat every other student.
Can someone remind me whether we fall under option 1 or option 2? What's our current practice?
For this one, we actually have, let me get to the policy, but I believe we actually have both options in the current policy.
Oh,
Yeah. But for us, the one that we opt for is the option 2. So all the wages and salaries and benefits for the food service employees are paid from the cafeteria fund. So it runs self-sufficient. So fees they collect pay for the staff.
thanks.
Just related to the earlier point, however, is if there is a meal debt for students, that cannot be paid by the cafeteria fund, and that's when the general fund has to cover that debt for students.
PK, what was that total amount? Do we have that tracking over time? Because I know that the board has talked about this and sort of made the decision time and time again to continue to make sure that students who have meal debt, that we're not sending them to collections and that we're continuing to feed those kids. And the amount has gone up pretty significantly in recent years, if I'm remembering.
You are correct. At the first year that this went into effect, it was around $20,000. I believe last year we had close to $100,000 budgeted, although I think we didn't reach that threshold due to the pandemic and the ability to feed all students regardless of their qualification for free reduced.
But yeah, I think it did increase to somewhere around 80,000 if I'm remember. And then now the current regulations continue to allow us to feed all students regardless if they're 18 or younger, regardless of where they go to school or whatnot. And so we don't anticipate a lunch debt this year because of those regulations.
Maybe not specific to this policy, but I think, I think I see Dr. Lusk in the room, and I don't know if there's any advocacy that CSBA can continue to do to extend the waiver that USDA issued so that in the future we are able to continue feeding every kid that,
Yeah.
for whatever their reason, needs to come through our lunch line. I think that's that's an issue that really deserves and requires some additional advocacy from CSBA and every local school district.
Thank you for sharing that, because that's one of the things that the delegate assembly will be discussing. You know, we have a number of issues that have been brought to the attention of the board of directors. So thank you for sharing, and I'll make sure I speak to that at the opportune time, okay? And I appreciate your asking the question relative to the, you know, how we've increased the coverage of families and children that are not able to pay their, you know, their food bills. So is there a way for us to just kind of get an overview of the increase? Not necessarily something that needs to be reported at the board, but just put in our package so that we as board members can be aware.
Absolutely. The next policy is BP 3555, Nutrition Program Compliance. This policy was updated with two things. The new state regulation, which provides that any complaints regarding meal counting, claiming of reimbursable meals, eligibility, or the use of cafeteria funds, if those are, if there's an issue with that, that's reported directly to the CDE. But if there are any complaints alleging discrimination on bias of race, color, national origin, sex, age, or disability, those go directly to the U.S. Department of Agriculture, who oversees the federal free and reduced lunch program. And that's the two changes for board policy 3555.
I'm looking at, the board shall designate a compliance coordinator for the nutrition program, and maybe that's on another, are you on that one at this point? Or
You're on.
35,
Well,
board
yeah, we're on the
policy,
board policy.
3555. Am I on the right one? Okay. So our compliance coordinator for the nutrition program would be,
I believe it's same as the unified, the uniform complaint officer, I believe. That's how
It'll
we
be
have it.
Dr. Nunez.
Yeah, Dr. Nunez.
okay, that would be Dr. Nunes. Okay, all right, that's good to know. I just curious. Thank you.
We do have option on that one, right?
Yes.
On this here, we have two options, but from my, let me look at this.
Okay, 1 and 2. I'm not looking at the right one, yeah.
Yeah.
Within 60 days.
So I think the option is either 60 days for option 1 or 30 days for option 2. And option 2 adds a within 5 business days, if the person is unsatisfied, they can write, yes, file a complaint with the
With the board.
So I think we're comfortable with either of these options. So it really would be your recommendation to the board, which one to pursue.
So I'll just share that, you know, since we have a compliance coordinator, I see giving us 60 days, giving the option 1 is what I would recommend, so that we can give staff the opportunity to investigate the situation and prepare the written report. I think option 2 just kind of moves us quickly and involves the board at, I think, a stage that would be too early. That's just my thought. So I would like to stay with option 1, giving us the 60 days to investigate. That's my recommendation.
I'd support that line of reasoning. That makes sense.
All right.
Okay.
So we'll make note of that as well. And then, is that it, right?
Yes, that's it on that. There's one exhibit for BP or for that board policy 3555. And this is just the non-discrimination language that we already include. This is putting it into an exhibit in board policy. But this is something we already do provide in our communication.
Okay.
Okay, there's no more board questions on any of these. I'll make sure we give an opportunity for the public to have any public comment.
There's none in the chat.
All right, Seeing none, I'll ask the board for a motion to recommend these go forward to the full board with the changes and options recommended by the policy committee.
I move that we move this forward to the full board.
And I'll second that.
Moved by- All right, Dr. Lusk, seconded by Ms. Askew, and I'll do a roll call. Dr. Lusk,
Aye.
Dr. Whitmire,
Aye.
Ms. Ruth Askew.
Aye.
All right, motion passes. Excellent. Thank you, Mr. Altemeyer. All right, we'll move forward to 2C. These are items, board policies, administrative regulations having to do with communications and engagement. So I'll turn this over to Ms. McFadden. We also have our senior director, Ms. Katie Rivera, because this has to do with special education. So she's here to answer any questions as well.
Okay, so BP 0430 is comprehensive local plan for special education. And basically, this policy was updated to reflect the requirement that the special education local plan area submit its local plan to the County Office of Education and or the Superintendent of Public Instruction, and the requirement beginning July 1st, 2020, and to review that plan every 3 years. The policy also clarifies the different types of SELPA governance structures and adds an option for arrangements in which the district joins with other districts in the County Office of Education to form a SELPA. The policy also deletes material related to the referral and eligibility of students for special education, which is addressed already in AR 6164.4, which is the identification and evaluation of individuals for special education. Finally, the policy adds a requirement to adopt a procedure for the ongoing review of programs and a mechanism for correcting any identified problem. And I'm going to, I think, defer to Katie, because I believe on option 1, it's single district SELPA, and option 2 is districts that participate in the multi-district SELPA. Are we option 2?
I think we're option 3 actually, because we're multi-district with the County Office of Education.
You're right. I missed option 3. So we're option 3.
Mhm.
So that's basically what the updates are to this board policy. Okay. Then the next one is the accompanying AR 0430 with the same name. And the regulation basically is updated to reflect the new template for the SELPA plan developed by the CDE. And then section on definitions are revised to delete definitions for terms which are no longer used in the policy or the regulation. And then the section on the elements of the plan expanded to include further details regarding required components. The regulation also reflects the new law, SB 75, which was adopted in 2019, which requires the SELPA plan to include an annual assurances support plan beginning July 1st of next year, 2021, based on a CDE template developed by July 1st of 2020. So the regulation also adds a requirement that each school post a notice of the public hearing that will be held by the SELPA to adopt the plan, and adds a new section on availability of the plan, which includes a request to post the SELPA plan on the district's website and make it available at the district office. So that's basically the two updates to the BP and the AR. And that's what we have in today.
All right, any board member questions on this? Dr. Whitmire?
I just wondered if Ms. Rivera had any comments or suggested changes.
No, pretty straightforward. So,
Okay.
thank you.
Thank you.
All right. All right, I'll entertain any public comment on any of these items.
There is nothing in the chat.
All right, seeing no public comment, we'll go back to the board to ask for a motion to move this forward to the full board for consideration.
I'll move this forward to the full board for consideration.
A second?
All right, moved by Ms. Rudascu, second by Dr. Lusk. We'll do a roll call. Dr. Lusk,
Aye.
Dr. Whitmire,
Aye.
Ms. Rudascu.
Aye.
All right, we'll pass this forward to the full board and move forward now to items having to do with educational services. And I think we'll have some support from human resources in part of these as well. No? They're all students.
One, but we want to work with.
Okay, perfect. All right, so I'll turn this over to Ms. McIntosh and Ms. Wadecki.
First up, we have BP 5125.3, which is international transfer. This regards giving guidance to obtain, interpreting, and evaluating international transfer. Usually this is not an issue, but once in a while we will receive a difficult transcript to interpret, or if a student's coming from an area that's been decimated by war, or doesn't have transcripts, something like that, it does give some people within the ability to evaluate the transcript or any other record or any other information that they have from the transcript into a student high school. And then based on the student transcript or the record, the central shall award the appropriate unit of transcript credit, appropriate place the student in.
Questions on this one? All right, move forward to BP 5145.
Yes, this is BP 5145.3 as well as Administrative Regulation 5.43 or 45.3. Both regulations have been updated to reflect new law AB 34, which took place in 2019, which is asking us to post our non-discrimination policies, specifying the state laws regarding discrimination, bullying, harassment in prominent location on the district site in a manner that is easily accessible to parents and guardians. The administrative regulation is also updated to reflect new law AB 711, which requires our district to update a former student's records upon receiving issue documentation or a written request for a name and or gender change. And so these items have all, we actually updated these because of the federal audit in terms of the way we posted our information, as well as that one recommendation, however, that I would offer is, or if possible, on the BP 5145.3, at the very end on page 3, the strike through in terms of the contact information and how we follow up with complaints is strike through, but based on our previous audit, I would like to recommend that we keep that in that board policy. And that's the next board policy we have is on parental notifications. It's board policy 5145.6, as well as the exhibit. And that particular board policy, the board policy reflects the new language that's been placed in the exhibit. But that is for new law SB 74, which extends the suspension of certain mandated activities. And it also addresses new federal regulation, which requires a notice of contact information of the district's Title IX coordinator. And it also identifies and updates new law SB 1109, which requires the dissemination of the opioid fact sheet to parents and guardians. And that we also, and new law AB 2370, which notifies families around the testing for lead, and that it adds in requirements for districts receiving impact aid for children residing on Indian lands, which is what Mr. Altmaier spoke of. It also identifies new federal regulation, which requires a notification of parents and guardians for students who complain of sexual harassment, and that we're very clear about the complaint process, and that we move the classroom notice requiring that, and ensure that our state preschools are addressed through our uniform complaint processes and notifications. And that is that. You want to address Title IX?
Yeah, so that is also a new AR, and that's reflected for the Title IX sexual harassment process. To update new federal regulations, as I mentioned earlier, it amends the process for resolving sexual harassment and the requirement to designate a Title IX coordinator or disseminate the contact information across the district. And you see my name's cluster all over, this contact information, but that's a good thing that they have that information. I know it's to the FTM audit, but it's a new AR, and we feel good about it.
And this, in terms of the harassment, bullying, and Title IX policies and procedures, oftentimes the policies are reflected both for the adults and the students. They're symmetrical in terms of education and posting policies. The next one we have is BP 6020, parent involvement, and AR 6020, parent involvement. And that basically identifies the ways, it's very specific in terms of our local accountability plan and how we post and provide parents information around that. In addition, it adjusted in the administrative regulation, it adjusted the language to reflect more around district processes rather than just specific parent involvement around Title I schools. It's expansive that all schools engage in parent notifications for different strategies and district things.
Okay, so I'm sorry, I think I moved us a little bit too quick. So we want to go back to the, I believe the sexual harassment one, and Dr. Whitmire, can you?
Unless we're going in a different order, I was looking at AR 5145.71. That's the Title IX AR.
Yes.
For students.
Yeah, that's correct. Yeah.
Okay.
Sorry.
I read through that one a couple of times because I wondered if I was missing something, but I didn't see anything in there since this is related to Title IX and students. I didn't see anything related to contacting or involving a parent or guardian. And I just wondered, since the ARs are like how it works in practice, I was unclear as to, since, Title IX is new and we're kind of figuring it out.
Yeah, so at least in the training that we received, it was very, the process is we have to keep, I guess the process is, it's very open. Sometimes we can even disclose the victim's name, and it's different. So at any point we want to bring in the parents, we would do it. Normally what they said and in their experiences, this was the F3 law group. The child comes in with the parent, most times to put the complaint, and then that's when the parent is in the know. But there are times where the child doesn't want the parent to know yet, and the investigator and the Title IX coordinator have to work with the child to get them to that place. So it's really up to you to tell us when we can do that, but these things are very tricky.
They are very tricky. That's why I was wondering. I mean, if you know, since you've been through the training, if your recommendation is that we leave it as kind of a gray area so that it's subject to the discretion of the situation, I'm comfortable with that. I just wanted to ask because it just wasn't covered in the AR.
Yeah, so it is in terms of the non-discrimination and harassment administrative regulation, it does identify the process of education and information that students and families need to be provided. And from there, it does outline notification in terms of how to engage in reporting and being supported in that process should harassment or not discrimination occur.
Okay.
Which is generally the Title IX is enacted.
Yeah.
Okay, cool. So it's covered elsewhere. Okay, I'm good. That's all I had. Thank you.
And just to add, in not in every complaint, but if there is a place where we feel uncertain about anything in the legal matters, that's when we do reach out to our legal counsel for them to provide legal guidance as well. So that's not we do that. It's not every case, but on cases that we feel like it's necessary, then we take that action.
Yeah, no, that makes sense. It's when things are elevated to Title IX status, it's a pretty serious occurrence. So that makes sense.
Absolutely. Okay.
I know I was buzzing to quite a few of them. Do I go back to parent involvement or do I go to ceremonies?
Maybe go back to parent involvement, just because I think I cut you off there.
Okay. I just finished up that, but basically the board policy reflects the processes that we need to engage in for family engagement, specifically around our local accountability plan. It also identifies what we need to do if we are receiving any Title IV parent involvement, which we do not, which is Title IV Part E. We receive Title IV Part A. And then it also adjusts some of the language in the administrative regulation that expands the parent involvement processes beyond schools that are receiving Title I funding, but identifies that all schools need to engage in district type of strategies to support family engagement.
Good.
All right.
Our next board policy is as well as administrative regulation is BP 6115, which is ceremonies and observances. And this board policy is updated to add the board's authority to designate any day as a holiday, in addition to those holidays that are designated by law, and to revise the date upon which schools close in observance of any holiday except for Veterans Day. It also adds an optional language, so this is something we might want to explore, that stating that the board may adopt a resolution to authorize the display of symbolic flags or banners in support of specific awareness days or months. And so I don't know if we want to explore that language further at this time.
Didn't we have this discussion?
We did, yeah.
Because we displayed the pride flag.
That's exactly right. That we did discuss during the Pride Month to display the Pride flag at the district office. We had some technical difficulties pulling that off with the way that our flagpole is currently set up, but we can work on that. But yes, we absolutely have discussed that. Indeed.
So would we like to keep that language?
I'd like to keep that language. In fact, it kind of goes along, Marcy and Beth, with the discussion last night in the African American Parent Advisory meeting. So I'd like to see us keep that language.
And just that's why I missed ask you had to leave the meeting a little early.
Okay, thank you. Yeah, before we move off of this one, also, in terms of days and holidays, I do know that some government entities have named Juneteenth as a holiday. And so that's certainly something that we could consider, as the board can consider. Just know that we have to work with, we usually do our calendar a year in advance with our labor partners, right? So we'd have to plan ahead, but that's certainly, when I started hearing other government entities doing that, it certainly kind of brought that forward as, potentially could be something for us to consider at some point.
I think that would be great, and that it just, kind of look at the equity.
And I appreciate that because that's what the administrative regulation is updated on, which is identifying it. Actually, I removed the specific language around Cesar Chavez Day and Native American Day, deleted from the actual regulation because those are days that are negotiated or in an MOU, but it still gives the board the authority to determine that, which days those are, even though those are, like, we can still look at those days, but it removes it from the actual days that we engage in. There's also a section that's expanded, which is the commemorative exercises. And it identifies additional days of significance in which the schools are encouraged, but not required to conduct commemorative exercises around those specific days.
Well, I don't know what the process is for getting Juneteenth on our calendar, but I definitely support doing whatever we need to do for the 2021 or whatever the next year is that we can work on that.
I agree, Dr. Whitmire. Thank you, I agree with that. This is one of the things that perhaps when we report these in our next meeting, the approval of them, this would be something to emphasize to the public so that, again, the parents that were questioning, celebrations and what have you, would hear,
Yeah, we can do
that
that.
we have board policies to support that. So, yeah.
All right, unless there's any questions, we'll move forward with physical education and activities, both the BP and AL.
Physical, board policy 6142.7, this policy update is updated to add statement on equal access and equity, equal opportunities for participation in physical education regardless of gender expression, sexual orientation, and mental or physical disability, as included in CBE federal program monitoring. It's also clarifies credential requirements for teachers of physical education, and also the reflects the requirement that students who have been granted permanent exemption from PE must still be offered PE courses for at least 400 minutes each 10 school days. The AR also reflects the new law SB 75 2019, which extends the use of uniform complaint procedures or UCPs to include complaints alleging non-compliance with physical education and instructional minutes in grades 7 through 12. It also expands the list of duties in the physical fitness test coordinator as described by state regulation.
I think it's pretty specific.
All right. Great. Then we'll move forward to the concurrent enrollment in college classes.
Okay, CPP 6172.1, and this policy is updated to reflect a no enrollment cap up until January 1st, 2027, so it's an extension. It also reflects a new law, SB 554, which authorizes an adult education student pursuing a high school diploma or high school equivalency certificate to attend community college as a special part-time student. This also reflects language around the CCAP agreement, the College and Career Awareness Pathways Agreement, and also as an extension of AB 288, which encourages students who are not already college bound to be in dual enrollment or concurrent enrollment courses while still in high school.
Any questions on concurrent enrollment?
I'm fine.
All right. Great. So the next one is an AR Title VI Indian Education Program, but I'll turn it over. Go ahead, Chris.
Yeah, it's specific around ways in which we would engage in utilizing funding that we receive for the Indian education programs, which is fully Title IV, but we do not receive funding for that. And so even though it is a new addition of an administrative regulation, we would like to offer up the recommendation of not adopting it as part of our administrative regulations, because we do not, this program does not pertain to our district.
I know this is something that is really being pursued by districts that do have this population, so I would support your recommendation.
Yeah, Cresta's explanation gets at my question, which was, I don't think we have this population, so.
Right.
Yeah. That's it.
All right. Well, thank you. If there's no further board questions, I'll give an opportunity for public comment. If there's any public comment on any of these items.
No one in the chat.
Okay. All right. So I'll take a motion to move these items having to do with educational services to the full board for consideration.
I'll move that we bring them to the board for consideration.
I second.
All right. Moved and seconded. I'll do a roll call. Dr. Lusk,
Aye.
Dr. Whitmire.
Aye.
All right. We'll move these forward for consideration. Next up is items having to do with student support services. So I'll turn this over to actually Marcy McFadden's going to take these first ones.
Yeah, the first one. Yeah,
Yep.
that's right. So board policy 1340 and accompanying AR 1340. So it's access to district records, and basically the BP is just updated to reflect new law, which is AB 1819, which was adopted in 2019. And basically it allows members of the public to use their own equipment on district premises, like free of charge, to photograph, copy, or reproduce our disclosable district record, provided that the equipment does not make physical contact with the record. So basically, when we've had public records requests, people would have to make an appointment and come in, and or they'd have to pay for copies and that whole thing. So now it's allowing them to bring in their own devices, so they don't have to pay for copies. Because we've had a request one time where someone brought their printer in and didn't do that, and so now this will update the policy to do that. The accompanying regulation basically updates the list of confidential public records to include the prohibition against releasing an employee's personal email address upon request from the employee. Regulation to also reflects new law, again 1819, which allows members of the public to use their own equipment free of charge to photograph, copy, reproduce a disclosable record on the district premises, provided that the means of copying or reproducing the record does not require the equipment to make physical contact with the record. does not damage the record, and does not result in unauthorized access to the district's computer systems or secured network. So pretty standard updates to these two policy and AR.
Just-
Yes.
Go ahead, Dr. Whitmire.
I just had this is a quick question. It's not related to updates to the policy, so I apologize. But the language says that the, charges should be based on actual costs of duplication. And then, in the olden days, that was like making physical copies, but it also costs in staff time. So I just wondered how often it is that we actually charge people for the time and effort it takes to provide records, or if it's strictly related to the physical copies. Just sort of on my mind.
Yeah.
It's related to the copy. So it's like a per page fee. We typically, we try to produce the records electronically where possible, although people can request a paper copy if they would like. And we do provide that. Typically, we don't charge the fee. And so it's very rare that we do that.
But
if at all.
to answer though, the staff time, unfortunately, that is not in the law. That's not acceptable to charge someone's staff time. You can communicate that the amount of time you think it will take, like this will take my staff a month, or 6 weeks or however long, but not charge them for that time.
Yeah. It's not staff time. It's the reasonable cost in case if you had to procure some specialized equipment or software, hardware, things to make that, those are potential costs. But it's staff time.
I see. So thank you for clarifying.
All right, we'll move on to infectious diseases. This is
I'll take these could be more timely. So BP 5141.22, this policy reflects the new law AB 262, which requires the local health officers to notify and update districts on any outbreak or imminent outbreak. It also requires districts, of course, to comply with any orders issued by officers. This policy also clarifies that any allowable exclusions apply only to cannabis instructions. And additionally, that the superintendent designee, when necessary, will of course inform the health official of any potential outbreak that is noticed within the district.
questions on that?
This one seemed both timely and forward, so no questions.
All right. Move forward.
Move forward. All right, the AR 5141.22. This regulation really just updates and adds a section on the prevention and mitigation plans. It really just reflects general best practices based on our experience through COVID-19 and the guidance that we received. It also adds recommendations from CDE's Science Safety Handbook, which pertains to any sort of experiments involving human blood sampling, which would occur normally within a lab science class in general. So that's pretty much what this AR is. I imagine moving forward, we will have more updates on infectious diseases.
Yes, I'm good.
Okay. All right, we'll move forward then to the next BPAR, suicide prevention.
Mental health.
Oh, sorry, I skipped one. Mental health. Yeah, sorry.
That's okay. So we're on to the BP 5141.5 on mental health. This is a new policy. And this policy addresses strategies, services, and promoting students' emotional well-being and mental health, including student instruction, staff training, crisis intervention, counseling services, referrals, etc. Policy reflects a new law, SB 75, which does establish the Mental Health Student Services Act, which is in place to support the mental health partnerships among mental health agencies and local educational agencies. I'll just mention on this that I feel very proud of our district and the efforts around this, and this just really reflects the work that's going on in our district right now. We have a very just amazing team who are ready and responding to our student mental health needs, and including youth mental health first aid training that's going out to staff. We're rolling out a teen mental health first aid curriculum that will be piloted at Marina High School, which will roll out that goes directly to students. We have a lot of great work in this area.
I'm so excited to hear, or to know that we are really on top of this, because the need is so great.
Okay. All right, so we'll move to the suicide prevention.
Okay, so this is BPAR 5141.52, suicide prevention. This is an update reflecting two new laws. The first, AB 1767, which mandates age-appropriate policy on suicide prevention, intervention, and postvention, specifically for students in grades K through 6. It does reflect requirements in consulting with stakeholders on any policy development, coordinating with the county mental health plan whenever referral is made for mental health or related services, again, for students that are in grades K through 6. And then it also updates with the new law AB 34, which requires the district to post its suicide prevention policy in a prominent location on its website. It also moves material regarding the printing of the National Suicide Hotline number on student identification cards to a whole nother section. And it adds an optional postvention strategy to identify and monitor students significantly affected by suicide and those at risk of immediate behaviors. I would say, just to add on to this, we do have a very comprehensive suicide prevention, intervention, postvention handbook and guidelines that really guides our protocol and our process in responding to any risk assessments and suicide responses. The additional strategies included are within our handbook.
And I'd like to add that it was when we were audited for this particular policy, it was absolutely imperative that those strategies were in the policy. They needed to be in the policy of administrative regulation, regardless of all the other things that you had, because of the importance of it, just at the federal level as well. So our district has been really ahead of the game in that way.
Thank you. Good to hear.
Okay,
Very proud of us. We are ahead of the game.
all right. Excellent. Okay, we'll move now to 6159, Individualized Education Program. And this is where we'll have Ms. Rivera come
We
in.
have one more that.
Oh, I keep trying to move too fast. I'm so sorry. I apologize. Go ahead, Mr. Everett.
That's okay. So we, BPAR 5144.1, this is a suspension and expulsion due process. So this is policy that updates two new laws, SB 419, which prohibits districts from suspending students in grades 4 through 8 for disruption with school activities or willful defiance. This policy also, and the other law, AB 982, which requires a district to provide a student who's suspended for 2 or more days access to homework during the period of that suspension. It adds a new section on there for additional grounds for suspension and expulsion, and it reflects an option, which if you look, it gives 2 options to suspend but not expel a student in grades 9 through 12 for disruption or willful defiance. And our recommendation is to go with option 2, that no student may be suspended for disruption or willful defiance except by a teacher pursuant to Education Code 48910. And this is based on our board recommendation, our board a couple of years ago, I think we had a discussion on this.
We did. We had that discussion. I accept that recommendation.
Yeah, I think I'd keep to our prior conversation on that, which was, again, MPUSD ahead of the game, no students being suspended for willful defiance.
Right.
Okay. Now we'll head to Katie Rivera. Thank you.
You're just so excited to talk about SPED, IEP requirements. This board policy 6159 is just updating, get my notes here. Policy is updated to include the requirement that was formerly in board policy and 0430 regarding the comprehensive local plan for special education. This is to provide free and appropriate public education or FAPE to students who have been suspended or expelled from school or who are placed by the district in a non-public school. This policy adds the requirement to provide FAPE to individuals aged 18 to 21 who are incarcerated in an adult correction facility if they were eligible for an IEP prior. And then there's a paragraph on the rights for foster parents that were moved to the administrative regulation. Okay, and then administrative regulation 6159, I think that's, yeah, where you are. This regulation updates a section on the content of the IEP to consolidate the list of IEP requirements for clarity. That reflects the new SB 98, which was just put in place in 2020, which requires the IEP to describe the means by which the IEP will be provided under emergency conditions, in which instruction and/or services cannot be provided to the student at a school or in person for more than 10 school days. The regulation also reflects the new law AB 947, which was approved in 2019, which authorizes districts to consider elements of the expanded core curriculum as defined within the developing IEP for a student who is blind, has low vision, or is visually impaired. 2, establishes requirements for orientation and mobility evaluations to be conducted for students who require them. Regulation also reflects the new law AB 605, which requires districts to provide assistive technology devices for use in a student's home or other setting when required by the student IEP, and then requires that such students be given continued access to assistive technology devices for up to 2 months after transferring out of the district. The section on parent-guardian consent for provision of special ed and services was revised to be more directly reflected in the law. I think.
Right. Any questions on these last ones? All right, well, we've reached the end of this section, so I'll make sure we have time for any public comment on these items. All right, seeing none, I'll ask for a motion to move the student support services, VPs and ARs to the full board for consideration.
So moved.
Second?
All right, moved by Dr. Lusk and second by Dr. Whitmire. And I'll ask Dr. Lusk.
Aye.
Dr. Whitmire.
Aye.
All right, we'll move these forward. All right, now we'll do items that fall under the superintendent. Although with the special education, I will at that time I'll call again for Ms. Rivera. This first BP is 0420.4 on charter school authorization, and it is updated to based on the new laws AB 1505 and 1595, which extends the time period district has to hold a public hearing for a charter application, and make sure that the staff recommendations are published at least 15 days prior to the final hearing when a decision is made. It also reflects the laws AB 05, AB 1595, which revised the required components of a petition, which deletes the reference to annual goals and adds a requirement that the petition describe the means in which the charter school will achieve balance in special education students and English learners that's reflective of the general population within the district. And also requires that the charter school include the names and qualifications of their governing body. Finally, it reflects a new law, AB 8982, which requires the petition to include the requirements for providing homework assignments upon request for students who are suspended for 2 or more days, as well as limiting the ability of charter school to establish a resource center, meeting space, or satellite facility used for non-classroom based instruction or independent study outside the district's boundaries. So that's the both the BP and AR for 0420.4 charter authorization. Any questions on these? So you may have remembered we had to follow this process in the ISM charter petition, and we continue to follow these new guidelines already. Okay,
I'm okay with that.
great. All right, I'll move forward to then charter school oversight, BP 0420.41, including the exhibit for that. So this reflects new laws, AB 1505 and 1595, which require charter school to request a material vision to its charter whenever it proposes to expand operations at 1 or more grade levels. And it the exhibit is added new requirements to the charter school regarding refraining from discouraging a student from enrolling for any reason, which is SB 75, to hold a public hearing when adopting their local control accountability plan, SB 75, and to provide assistive technology devices to a student at home or a student who transfers to another school, which was AB 605. It also prohibits the student they must pay the tuition for a student who attends a non-public, non-sectarian school. It phases in the requirement for teachers to hold a certificate or permit required for their certificated assignment. It requires that they provide parent and guardian notices in English and in the primary language when 15 of their 15% or more of the students speak the language other than English. They must provide students with a meal of their choice, regardless of unpaid meal fees. Adopt a policy for suicide prevention, applicable to grades K-6. Print the National Domestic Abuse Hotline number and student identification cards. Post the bullying and harassment prevention policies, and provide students who are suspended with one or more 2 days with homework assigned for the period of suspension upon request, and must update and reissue a student's records, former students' records, to include the student's updated name or gender. So that's the exhibit reflects the current law required to accept full or partial coursework completed for a foster youth, homeless youth, former juvenile court student, child of military, migrant student, immigrant student. So in short, it in many of these areas, it holds the charter school accountable to the same regulations that public schools are accountable for. Yes, Dr. Whitmire.
I had a couple of questions from the exhibit on page 5 under curriculum and instruction, number 27. Says if the charter school offers kindergarten program, they also have to offer transitional kindergarten program for kids whose fifth birthday is from September 2nd to December 2nd. And that, I think that's in conflict with our charter school. So if we adopt this, will they have to implement a TK program?
Yeah, so this is, we've looked into this. So the CSBA interpretation of the law is just that, as you described. The charter school interpretation of the law is in conflict with that. They don't believe that that's what the law says. So there's a legal conflict. For new, I looked into this for the ISM, because they were reapplying to renew their charter. They did not have to comply with this TK requirement. If they were a new charter, then we would have been able to ask them to require on that. With that said, ISM is open to discussing, that they would provide TK in the future, but they did not have to include it as part of their charter renewal application.
Okay. And then, let's see, on page 11 of the exhibit, number 63, there's language about not recommending expulsion in grades K-12 or K-8 for willful defiance.
Yeah.
And I couldn't remember what ISM's policy was on that. And so I just wondered if this was consistent with their practices at the moment.
I'll have to look into that and get back to you. I do know that I believe that that the California law changed, and that now it applies to, so that if it isn't in their current policy, they will have to change their policy to comply with this updated law.
Okay, I'd like to see that happen.
Okay.
Yeah.
Mhm.
And that's all I have from this one. Thank you.
So I have a question
Yes.
that relates to the monitoring of charter school performance.
Yes.
I don't think that's an issue for ISM, but I do recall years back that we had a charter Learning to Life that we had to provide some support there, some technical support.
Right.
When students were not, when we found that students were not meeting their performance standards.
Mm-hmm.
So what department would provide support to our charters if we monitor, their educational performance? So would it be our, on the grade level probably, huh?
Yeah, so I think it would be the superintendent's office would monitor the performance. If there was required intervention, then it would be that the Ed Services Department would provide the intervention. I believe under the new color-coded assessment dashboard, that those who are in need of assistance also have an avenue to seek support from a outside provider or county office of education. So they don't have to get support from their charter authorizer,
Okay,
but they have to get support if they qualify.
okay,
Mhm.
all right. So, but do we directly monitor the charter schools, ISM and other charter, we do?
Yes,
Okay,
through the, we don't monitor, say, like their interim, tests that they give or whatnot, but in terms of their dashboard and how
Okay.
they're doing regarding the state dashboard, then
Okay.
that's our responsibility to monitor that.
And so if there were red flags, then the board would be made aware of it. at
Yeah,
some point,
well,
or-
for example, just recently, Dr. Diffenbaugh reached out to one of the schools and inquired about their LPAC testing and their process and
Okay.
their ever EMOs and that sort of thing. So we do reach out when there
Okay.
seems to be data that's arise.
That's
Or that we have questions about.
perfect. That's exactly what I needed to hear. Thank you. I'm fine.
All right. There's no more questions on that. I'll move over to the charter school renewal, BP 0420.42. So this is updated, revises the criteria for granting or denying charter renewals, provided that the renewal is a high-performing charter school may be granted for up to 7 years, and provides that a low-performing charter school shall not be granted renewal unless it adopts a written plan with meaningful steps. It also extends the deadline for holding the public hearing and does require the 15-day notice prior to a final decision by the school board. Section on school closure is also added to clarify that if the charter school is not renewed and ceases operation, closure procedures specified in the charter will be implemented.
Good.
Okay. All right. Final one for me on this is the charter school revocation. So this is updated to move material regarding immediate revocation of a charter school in an event of a severe or imminent threat to the health and safety of students, and reflects the new law AB 1505, which provides that increases in student achievement for all numerically significant student subgroups should be a factor, but not necessarily the most important factor in determining whether to revoke a charter. And it has a similar section on school closure about following the operation of the charter to be implemented should it cease to exist. Yes, Dr. Wood.
PK, is revoking a school charter the same thing as not renewing it, or does revoking a charter happen sort of like at a non-specified time, based on conditions?
Correct. So a revocation would usually happen if there was severe financial issues, if there was, systemic abuse or some sort of other issue that was brought forward, or as it mentions, if there's some safety or health threat to students. So it would be not waiting to the end of their charter and not renewing, but stepping in and doing something more immediate. Usually there is an opportunity for a plan to be developed and monitored and improvement that way, but there are times if there's something very severe that the charter would be revoked by the board. Usually that's when there's a major financial issue at hand.
Okay, thanks.
Okay. All right, so now we'll move to individual education, the procedural safeguards for special education. So I'll turn this over to Katie Rivera.
Yeah, thank you. So this policy is updated to encourage early informal resolution of any dispute regarding special education services. Policy also reflects a new state regulation, which is Register 2020 number 21, which establishes a complaint process separate from a UCP complaint for complaints alleging non-compliance with federal or state laws related to the provision of FAPE for students with disabilities, such as a district violation of the Federal Individuals with Disabilities in Education Act, or state law on special education, a violation of a settlement agreement, failure to implement a due process hearing order, or a physical safety concern that would interfere with the provision of FAPE. The Administrative Regulation 6159.1, also around procedural safeguards for special education. This regulation was updated to clarify that due process complaints should be filed with the State Office of Administrative Hearings, and that such complaints must generally be filed within 2 years of the date of the alleged violation. Regulation also adds a new section on state compliance complaints, again reflecting the new state regulation that I mentioned above in the board policy. I think that was it for that one.
Any questions on that?
I have none.
Okay, go ahead, Katie.
Okay. The next board policy is 159.2, the non-public, non-sectarian school and agency services for special education. This policy is updated to include the provision of non-public and non-sectarian school and agencies, or NPS and PAs, which serve the Comprehensive Local Plan of Special Education, or SELPA. This policy reflects the new law of AB 1172, which requires districts to verify that the non-public schools or non-public agencies are providing their staff in training in the use of practices and interventions specific to the unique behavioral needs of the student population that they serve. This policy also reflects the requirement for the district to pay the full amount of the school's tuition, or as amended by AB 1172, the fees for that agency. The legal citation is that for this is Educational Code 56366.3, and it was deleted as it was repealed. And then, sorry. And then the last one is the Administrative Regulation 6159.2. This regulation updated to include the maximum term of a master contract between the district and the non-public school or non-public agency, expanded to expand the components of the contract in accordance with the state law and regulations, and to include the ability to terminate that contract for cause with 20 days notice. The regulation also provides more detail regarding the annual IEP review focused on non-public schools and non-public students. There's a new section on the site visits, which is reflective of the new law, AB 1172, which one requires the district to conduct an on-site visit of a non-public school or agency the first time the district places a student in that in one of those non-public school or agency. Number two requires the district to annually conduct an on-site monitoring visit to review the services provided to the student, look at the facilities as well, and the student's progress. Just to add a piece of that, through our current MOU and the interagency agreement within the SELPA with Monterey County Behavioral Health, that last portion of actually doing the on-site visits annually, it's in the agreement that that Monterey County Behavioral Health would do the on-site visits on behalf of the district. Since the majority or all of the students within our county who are placed through the districts are co-funded through the district and behavioral health.
Okay, any questions on the non-public, non-sectarian school of agency, DPAR?
I have no question.
Okay. Excellent. I'll give an opportunity now that we're done with covering these for public comment. If there's any public comment on 2F. Don't see any public
None?
comment.
Nope.
So I'll ask for a motion to bring these forward to the full board for consideration.
I'll move that we bring these forward to the board.
My second?
All right, thank you. Do a roll call. Dr. Whitmire,
Yes.
Dr. Lusk.
Aye.
Wonderful. We'll move these forward. And we have reached the last item of adjournment this evening. So would love to entertain a motion to adjourn.
I move that we adjourn.
Second.
Excellent. Moved and seconded. I'll ask Dr. Lusk
Aye.
and Dr. Whitmire.
Aye.
Thank you both so much. Really appreciate it. And
Thank
thanks
you.
to all the staff for participating and for Isai and Marcy for setting it up. So
Thank you.
appreciate it. All right, thank you.
guys.
Have a good night.
Happy holidays.
Bye.
Bye-bye.
Okay.
Happy holidays, guys. Enjoy.
Yes.
You end the meeting?
No, you want me to end it?
No, I'm asking.
No, I can end it.
Okay.
Oh, you have to end it.